Okay. I think the viewing experience will be a lot better now that it's full screen. I apologize. These are the topics that I'm going to discuss. We'll start out with a basic overview of trust fund taxes and then move on to the trust fund recovery penalty, discuss the elements of liability, go over some administrative procedures, discuss collection due process in the framework of trust fund taxes, discuss bankruptcy and the trust fund recovery penalty, planning for the trust fund recovery penalty, and contribution among responsible persons. So the Internal Revenue Code requires payors of amounts to withhold for taxes amounts paid to certain individuals. And this is most commonly encountered and seen in the case of an employer who is paying amounts to employees. And this is usually in the form of employees' wages, where the employer has to withhold from employees' wages their share, meaning the employees' federal income taxes and the employee's share of FICA taxes. So the employer serves as a withholding agent in the sense that they're acting on behalf of the Internal Revenue Service to withhold the employee's part of or employee's share of federal income taxes and FICA taxes. These withheld taxes are commonly referred to as trust fund taxes. And there is a theory behind the trust fund taxes, and that is that the employer has paid the amounts to the employee so that the employer is no longer entitled to the amounts, and by retaining them, holds them in trust for the government until they're paid over to the government and applied to the employee's tax accounts. Now, what's interesting is that in so many cases, as we will see, the employer does not withhold and pay over to the government. And the most commonly asked question is whether the employee gets credit for the amounts that the employer should have otherwise withheld. And the answer is yes. So even in the case of a defunct employer that does not withhold, and there are plenty of reasons why the employer might not withhold, one of which is that the company has fallen on hard times, and to keep the business afloat, they have to use that money that otherwise should have been segregated and paid over to the government for the trust fund. They have to use it for other matters to keep the business afloat, such as paying for inventory, paying their suppliers, paying their vendors, and in several cases, if they don't, the company may no longer be solvent and may go under. So I in no way mean to refer to an employer who does not withhold as being a deadbeat or anything like that, because these situations come up more frequent than not. All I mean to suggest here is that the employee does get the benefit of of credit towards these taxes, even if the employer does not turn them over to the IRS. So even though the funds are designated trust funds, there's no requirement that after withholding and prior to remitting to the government that the funds actually be held in some type of segregated trust fund or account. So an example of that might be if, as attorneys, we are oftentimes required to hold funds in escrow when we are retained by a client. In the case of the trust fund recovery penalty, the employer does not actually have to hold those funds in a segregated trust fund account that is labeled as such, like an attorney would have an obligation to hold money in an escrow account. Prior to being turned over to the government, the employer holds the funds and can use them for any purpose whatsoever. Although the person or persons directing their use for purposes other than payment of the trust fund tax can be liable for the trust fund recovery penalty or even a collateral criminal penalty. So what's interesting here is that there is no a hard and fast rule that requires the person or persons directing the use of the trust fund penalties to use it for that purpose. The money can be used for any purpose whatsoever. The problem is when the money doesn't get turned over to the government. So even though the money that is allocated for the trust fund recovery penalty, if it goes for other purposes, so long as the responsible person squares up with the government doesn't care if the specified lot that was otherwise meant for the trust fund recovery penalty goes to some other purpose. They just want to be paid. The government has to credit the employee with the amount withheld even if the employer does not remit the withheld amounts to the IRS. So if the employer goes belly up, or if the employer is deadbeat and just never squares up with the government, the employee does not suffer the wrath of the IRS. They still get credit for the amount that the employer had to withhold. So here's a good example. It's a quick and dirty example of the court's view of the trust fund tax and the employer's responsibility. Actually, this is some language out of a key case, and I apologize I don't have the citation for you, but this case was decided a while back, and it gives you some perspective of how the courts view withholding taxes. And that is that they're part of the wages of the employee held by the employer in trust for the government. The employer, as a function of administrative convenience, extracts money from a worker's paycheck and briefly holds that money before forwarding it to the IRS. A delinquency in trust fund taxes is not simply a matter between the IRS and the employer, but rather involves employee wages. The significant responsibility is summed up by Judge Cardozo's famous statement that, quote, a trustee is held to something stricter than the morals of the marketplace, not honestly alone, but the punctilio of an honor the most sensitive is then the standard of behavior. This is the example that I was referring to earlier. An employer owes an employee $500 for wages, and based upon the withholding requirements, must withhold $50 for the employee's income taxes based on the employee's W-4 and the related withholding tables, and $37.50 for the employee's share of FICA. Now, I realize that these may not be realistic figures, but this is just a quick and dirty example to illustrate how the trust fund recovery penalty operates. What would happen in this case is that the employer writes a check out to the employee for $412.50. The employee, of course, gets the check and is surprised to see that the full $500 isn't there and that he or she is missing a substantial amount. That usually happens within the first month or two, but then they see the itemized list of expenses and taxes and are quick to realize that there was withholding. And in this case, the employer actually withheld a total of $87.50. Again, $50 for the employee's income taxes based on the employee's W-4 and $37.50 for the employee's share of FICA. The employer is deemed through this fiction to have withheld the $87.50 from the payment and must turn that over to the IRS. It doesn't matter whether or not the employer in fact withheld. In fact, the employer may only have $412.50 at its disposal to pay the employee, and that's all the employer ever pays. Nevertheless, the employer is deemed to have withheld the $87.50. The employer is liable for that amount of $87.50, and failure to pay it over to the IRS would subject the person or persons within the employer's organization responsible for the failure to withhold to the trust fund penalty. When the employer fails to pay the trust fund taxes, it usually also fails to pay the employer's related taxes, specifically the employer's portion of FICA. So just to put this in context, not only must the employee pay their portion of FICA, but the employer also has an obligation to pay their portion of FICA. And so there's two portions of FICA that have to be paid: the employer's related FICA and the employee's related FICA. However, the employer's portion is not a trust fund tax. In other words, it's not another person's liability which is satisfied through withholding. In the example we just discussed, even if the withheld taxes are not paid, the employee will be credited against his income tax and credit repayments into the Social Security system. Essentially, the employer is the withholding agent for the government. Not surprisingly, given the amount of dollars in the system for trust fund taxes, the IRS most certainly has a vested interest in encouraging compliance with these requirements for withholding and paying over. As such, the IRS has major compliance functions in place to deal with potentially delinquent withholders. And Section 6672 of the Code is a section that imposes civil liability upon certain people other than the employer for unpaid trust fund taxes. The Code refers to the liability as a penalty, but it's important to make an important distinction here. We call it a penalty, but it's not a penalty in the sense that we otherwise would refer to a penalty. So when we call it the trust fund recovery penalty, it doesn't encapsulate delinquent penalties. It doesn't encapsulate the accuracy related penalty. It doesn't encapsulate the type of penalties that are triggered when we collectively think of tax penalties. It's called a penalty, but it only includes what we discussed earlier, which is the employer's portion, the employee's portion of FICA taxes and income taxes based on their W-4. So please don't get that confused, because if you've had cases like this before, you may have come in on it where the client has signed a stipulation with the IRS where they agree that they are liable for the trust fund recovery penalty, and they sign the equivalent of what is for all intents and purposes a closing agreement with the IRS to memorialize it. Well, lo and behold, after they sign it and they pay the trust fund recovery penalty, they begin to receive notices for penalties that were associated with the failure to pay the trust fund recovery penalty. And these penalties obviously can really get high. In addition, they are charged interest. And so the first thing that they start raising hell about is the fact that they've already squared up with the IRS and paid the trust fund recovery penalty. So why are they receiving these subsequent notices for delinquent penalties and interest on what they've already paid? And when you sit down and explain it to them, it doesn't make sense, because they think that colloquially the term penalty in trust fund recovery penalty encapsulated not only the amount that they otherwise had to pay over, but the penalties as well. And unfortunately, that is a misunderstanding, and it gets in the way all the time because the IRS uses the term penalty in a different context. So although the liability is related to the underlying trust fund taxes, it's still a liability separate and apart from them. The liability, as we've already covered, is frequently referred to as the trust fund recovery penalty. The circumstances that give rise to this penalty is that the employer is late in turning over trust fund taxes to the IRS and then is unable to pay them. When a business falls on hard times and is experiencing cash flow problems, anyone and everyone in the organization, from the CFO to the lowest level employee, I think would be on the same page about how important it is to keep the business afloat, come hell or high water, with whatever disposable cash remains on hand. and most of the time the cash that remains on hand to keep the business afloat is the trust fund taxes that were set aside for the IRS. And again, it's designed for a far more urgent need to keep the business solvent. The expectation, of course, is that the cash flow problem will subside and that the trust fund tax will be paid later. The withholding taxpayer often views his intervening use of the trust fund tax proceeds as a temporary expedient to get through a rough time, with every intention of eventually paying. If the business succeeds or the withholding taxpayer otherwise pays the delinquent taxes with interest, everybody lives happily ever after. But if the business goes belly up with the IRS holding the bag, as is too often the case, things go south. Now, Section 6672 imposes civil liability for the unpaid trust fund taxes upon those individuals who had the responsibility to ensure that the withheld taxes were paid over to the government instead of being used for other purposes. An individual is subject to the trust fund recovery penalty if two conditions are satisfied. First, that he or she was required to collect, truthfully account for, and pay over. And second, willfully failed to do so. I will tell you to be extra cautious here because the term willful is sometimes confused with the term willfulness in the criminal context, and many people think that it's such a heightened standard that it's impossible to brand a person with this or strap a person with a trust fund recovery penalty due to the fact that willfulness is oftentimes synonymous with knowledge of a responsibility to pay a tax and a deliberate failure to do so, but it doesn't rise to that level. Willfulness in this context is like a watered-down version of willfulness in the criminal context. So in many cases, willfulness is but a minor element that has to be satisfied, and we'll talk about that a little later. The statute refers to the liability as a penalty, but it's actually just a secondary tax collection mechanism for employers who fail to remit the withheld taxes to the IRS. A person who's subject to the trust fund recovery penalty may have direct liability for it, as well as other taxes of the employer. Under most states' general partnership laws, a partner in a partnership is generally liable for trust fund taxes as general partners separate and apart from the trust fund recovery penalty, and assessing the penalty might be an exercise in futility. It may not be necessary. By contrast, the owner of a limited liability entity such as an LLC will only be liable under the trust fund recovery penalty. So, as you can tell here, under states' general partnership laws, it's a lot easier for the IRS to assess the trust fund recovery penalty as against general partners instead of having to go through the rigmarole of satisfying all of these requirements. On the other hand, if it's a limited liability entity, the IRS has to satisfy the prongs of the test that we just discussed. Once again, I cannot overstate the importance of distinguishing between trust fund and non-trust fund taxes. In the employment context, withholding from the employee for income tax and FICA tax are trust fund taxes. So again, this is something that you're going to have to sit down and explain to your clients over and over and over again. And it's through no fault of their own. Again, this is a very murky area, and the IRS does not help things out by referring to it as a trust fund recovery penalty. It's only natural for a layperson or even a seasoned financial professional to assume that trust fund recovery penalty means not only the income tax and FICA tax that they should have paid over, but the delinquent taxes, the interest, and everything else that went along with it. And sadly, that's where things go south, because a lot of people think that by signing that closing agreement with the IRS to take full responsibility for the trust fund recovery penalty, that they are not only clearing up the income tax and FICA taxes that they otherwise should have withheld and paid over, but also any taxes, delinquent taxes, and interest that went along with that withheld amount. The employer's direct liability for the employer's portion of the FICA tax is not a trust fund tax. Only the employee's portion of the FICA tax, not the employer's portion. And therefore, it's the employer's portion of the FICA tax is not subject to the trust fund recovery penalty. In addition, delinquency penalties and accrued interest for unpaid trust fund taxes are not consolidated in the liability. That's why after some people execute an agreement with the IRS to pay a trust fund recovery penalty, they are surprised to find that a few months later they're receiving notices in the mail for penalties and for interest on the withheld amounts. The trust fund recovery penalty is merely the amount withheld, not including the employer's penalties or interest. However, once the trust fund recovery penalty is assessed, it bears interest. So even if the person acquiesces to this penalty and signs a special form, which we're going to get into later, which is for all intents and purposes, like I said earlier, like a closing agreement, that amount still bears interest, and a lot of times the interest is not included in the closing agreement, and sometimes comes in the form of notices after this recovery penalty closing agreement form is executed. More than one person can be and often are liable for the penalty. So the IRS can make multiple assessments. It's not limited to just one person. A responsible person liable, and again, this is the key phrase here, responsible person. Responsible person. That is part of the definition. And so a responsible person that's liable for the tax is not relieved of the responsibility to pay it, even if there's another person out there in the wind who is more culpable vis-a-vis the default. The IRS has the discretion to pursue anyone who they deem is responsible. And sometimes there's other people that are even more responsible that the IRS doesn't pursue, yet goes after the small fry. And in those cases, the small fry, of course, is incensed that the IRS has targeted them as opposed to someone who has even more culpability. And we're going to discuss a little later on what can happen in those cases where the IRS singles out your client as opposed to someone who's even more responsible. So as unfair as this may seem, the IRS need not make the assessment against a person otherwise liable, even if that person is dead to rights and is more culpable. Section 6672 imposes liability upon any persons required to collect, truthfully account for, and pay over any tax imposed by this title who willfully failed to collect such tax or truthfully account for and pay over such tax. One thing that we're going to cover in the next slide, I'll just give you a quick preview on, is that this "and" that you see here does not mean that all three elements are required. So the IRS doesn't have to prove that the person who was required to collect, the required person, did not collect, truthfully account for, and pay over. It's been interpreted by the courts, this phrase, required to collect, truthfully account for, and pay over. It's been interpreted by the courts as an "or" and not an "and." So the IRS merely needs to prove that the required person failed to collect, truthfully account for, or pay over. So "and" is a little bit of a misnomer. Before the Supreme Court weighed in, individuals who were assessed the penalty used to argue that they were not liable because their role with the employer didn't consist of each of the three stated elements: collect, account, and pay over. The Supreme Court rejected that argument and held that and actually meant or. It's mind-boggling how they could have arrived at that conclusion, but that is the state of the law today. Even with this holding, the key element for liability to attach is that label responsible person. The key to civil liability is control of finances within the employer corporation. So the power to control the decision-making process by which the employer corporation allocates funds to other creditors in preference to its withholding obligations. IRS Policy Statement PF60 sheds some light on who bears the distinction or the honor of being a responsible person, and it's found in Section 3. Responsibility is defined as a matter of status, duty, and authority. Those performing ministerial acts without exercising independent judgment won't be deemed responsible. And in Section 4, it says that in general, non-owner employees who act solely under the dominion and control of others and who are not in a position to make independent decisions on behalf of the business won't be asserted the trust fund recovery penalty. So the overarching issue here is who made the decisions that caused the company to default on paying the trust fund taxes. Fortunately, the courts have given us certain objective factors to identify the role of a person, and those usually guide the analysis. Now, this is a list of just a few of the salient factors. One is the person is an officer or member of the board of directors. Second, the person owns shares or possesses an entrepreneurial stake in the company. Third, the person is active in management of day-to-day affairs. Fourth, the person has the ability to hire and fire employees. Fifth, the person makes decisions regarding which, when, and in what order outstanding debts or taxes will be paid. Sixth, the person exercises control over daily bank accounts and disbursement records. And 7, the person has check signing authority. Now, none of these factors is dispositive, meaning if one of them is meant, it doesn't mean that automatically that the person is a responsible person. It's kind of like a balancing test where the court is going to do a thorough analysis to see how many of those factors are met. Certainly there are some factors that carry more weight than others, and just because 3 factors may weigh in favor of responsible person and 2 may weigh in favor of not responsible person doesn't definitively mean that the person is a responsible person. Again, certain factors are accorded more weight than others. It's simply a balancing test, and the court will basically weigh these factors. It's a very broad test. Not only does it cover key officers whose job responsibilities gave them a material role in making financial decisions, but it may also cover directors and shareholders of a corporate employer, even when they are not officers or employees of the corporation. Even more counterintuitive, it may cover persons who are not officers, employees, directors, or shareholders. However, it is the rare case that such a person would have decision-making authority, much less an incentive to participate in such decisions. So it is a rare case that a person who is an officer, a director, or a shareholder would not be deemed a responsible person. It doesn't cover persons with titles that may infer decision-making authority, but who the facts indicate were denied that authority. Once the court has attributed liability to a person who could have impeded the flow of business to the extent necessary to prevent the corporation from squandering the taxes. Now, courts seem to agree on the fact that a person doesn't have to have final or absolute control of the financial decision so long as they participated in a significant way. Now, because authority and power is a fluid concept and changes regularly, it's critical to focus on the person's role during the quarters at issue, during the quarters in which the trust fund recovery penalty was assessed. Liability attaches to a person only if the failure to pay the trust fund taxes was willful. And again, it's impossible to discuss willfulness in the context of tax law without referring to the criminal sections of the code, which often equate it with mens rea, the fancy Latin term for one's mental state. In the criminal tax context, willfulness is defined as violating a known legal duty. Outside the criminal context, the concept is more broadly interpreted, meaning it's more watered down. For purposes of its application to the world of the trust fund recovery penalty, willfulness means that the taxpayer possessing the responsibility knew that the employer was required to withhold and pay over the trust fund recovery penalty taxes, but did not. Willful blindness also applies here. It's also known as deliberate ignorance, and yes, it is the bane of most taxpayers' existence. This is because it's the watered-down version of the heightened definition of willfulness, as it was defined earlier. Again, knowledge that the employer was required to withhold and pay over, but did not. Willful blindness, on the other hand, simply means that the person had some semblance of an idea that the employer had to withhold and pay over, but didn't do its due diligence, meaning the person didn't do its due diligence to educate him or herself more on it, but had an inkling that the employer or that he should have been withholding and paying over, but didn't. So you can kind of see that it's like splitting hairs, but it definitely allows the government to prove willfulness a lot easier than with the common definition that we just discussed earlier, the knowledge. That's a heightened standard. With willful blindness, the government merely needs to show that the responsible person had an inkling or a suspicion or suspected that he or she should have been withholding and turning over to the government, but didn't educate himself or take any of the necessary steps to learn more about what that obligation entailed. And again, the IRS interprets willfulness in the trust fund recovery penalty context to include more than just a deliberate intent to fail to withhold and pay over. And this is how the Internal Revenue Manual interprets it. It's interpreted to be the attitude of a person who either intentionally disregards a law or is just plainly indifferent to its requirements. And I think the example that I was getting at earlier is one where the person is just indifferent, and basically careless and negligent to the requirements that he or she has an inkling or a suspicion of. In other words, even if specific intent to not pay the taxes doesn't exist, willfulness will be inferred whenever a person's actions are construed to be grossly negligent. Does willfulness exist if an employer receives funds that by law or by contract are committed to uses other than payment of the delinquent trust fund tax? Well, that poses an interesting question. And if an employer receives and holds assets in trust for a third party, he or she cannot use those assets to pay the trust fund taxes. And again, it might seem a little counterintuitive to some, but to others it may seem very basic and elementary. And what we're talking about here is the assets that are in trust for a third party. And that's the key distinction here. Courts seem to take a nuanced approach, and they distinguish between assets held by an employer subject to a legal restriction that's analogous to trust fund, and assets held by an employer subject to a contractual term that the assets be used for purposes other than the trust fund taxes. So to distill this and make it easy to understand the distinction, assets held by an employer subject to a legal restriction are entitled to be paid over the trust fund recovery assets, okay, as opposed to assets that are held by an employer subject to a contractual term. Those do not become preference, or they do not, assets held by an employer subject to a contractual term do not take precedent over the trust fund recovery penalty. Only assets held by an employer subject to a legal restriction take precedent or preference over the trust fund recovery penalty. So a responsible person whose employer holds assets under a legal restriction is not willful for failure to using those assets to pay delinquent trust fund taxes. However, a responsible person whose employer holds assets subject to a mere contractual restriction that they be used for other purposes is willful if the person doesn't use those assets to pay delinquent trust fund taxes. One court recently held funds are encumbered and thus not available to pay trust fund taxes only when certain legal obligations like statutes, regulation, and ordinances impede the freedom of the company to use its funds to fulfill its trust fund tax debts. Voluntary contract obligations like the lockbox arrangement at issue in this case do not encumber funds so as to prevent a willful failure to pay trust fund taxes. The statute unfortunately does not provide a reasonable cause exception to the trust fund recovery penalty, as do most penalties. Some circuits, however, recognize a reasonable cause exception. Other circuits, like the Fifth Circuit, state that the factors that might bear upon a reasonable cause inquiry are merely considerations to be used in determining whether a responsible person acted willfully. There are exceptions for unpaid volunteers to charities. So individuals serving as volunteers for tax-exempt organizations are exempted from the penalty if the following elements are satisfied. First, they serve solely in an honorary capacity. Second, they do not participate in the day-to-day business or financial operations of the charity. And third, they do not have actual knowledge of the trust fund tax delinquency. The exception does not apply, however, if it results in no person being liable for the trust fund recovery penalty. So I would say that that exception swallows up the rule above. But nonetheless, you should check to see if it's a tax-exempt organization. I certainly would not rule that out extemporaneously just because of a swallow all exception. I would certainly look and see how the organization is incorporated. Administrative procedures. Now we're getting into audits and appeals, assessments and predicates, statute of limitations, IRS policy to collect only once, and collection due process. When trust fund taxes are delinquent, the IRS's first course of action is against the employer. If the IRS is unable to shake the employer down for payment, it will conduct an investigation to determine whether the trust fund recovery penalty applies. Unlike the examinations that we are used to that come up in the context of income and perhaps estate and gift tax examinations, the trust fund recovery penalty is investigated by a revenue officer who is already involved in the failed effort to squeeze money out of the corporation. The investigation involves review of corporate records. And by corporate records, the IRS here is referring to documents like articles of incorporation, bylaws to see who has authority, and checks to see who had check signing authority, as well as interviews of people who are in a position to observe circumstances that might give rise to the liability. After concluding the investigation, the IRS will have identified at least one person potentially liable for the trust fund recovery penalty. The IRS will proceed by issuing a notice of proposed assessment to each person so identified. However, as a practical matter, the IRS generally won't assert the penalty if the person against whom the assessment would be made has no assets from which to collect. The notice gives a person an opportunity to seek administrative appeal to the IRS appeals section of the IRS. It's similar to the appeal that can be taken from a 30-day letter or a revenue agent's letter in the context of income and estate and gift taxes. If a person fails to appeal, or if the IRS appeals office sustains the examining agent, then the IRS will assess the tax. After assessment, the IRS initiates collection. The responsible person may avoid the collection procedures by posting a bond and pursuing refund procedures. The collection statute of limitations is suspended during this period, but the IRS may, as it always may, make a jeopardy collection, and that's if they fear that the assets could be used for other purposes and are vulnerable to being lost. So standard collection procedures are available to the IRS for these trust fund recovery penalty assessments, and that means that the IRS can make use of any one of the collection tools that it traditionally makes use of. That includes summonses, levy on assets, filing of tax liens to protect its interest in the taxpayer's assets, filing of nominee liens. Also, the IRS may enter installment agreements or offers in compromise with the employer or the person who has been assessed the penalty, the responsible person. However, if the IRS receives an offer in compromise from the employer, in assessing the viability of an offer based on doubt as to collectability, the IRS will consider its collection alternatives from persons liable for the penalty. Moreover, if the IRS compromises the underlying liability, it's unlikely that the penalty would apply to the amount abated pursuant to the compromise. So, as you can see, there's a lot of nuances here. The trust fund recovery penalty is an assessable penalty under 6671A. Unlike income, estate, and gift taxes, it's not required to give the taxpayer, the trust fund recovery penalty is not required to give the taxpayer notice of his or her rights to prepayment litigation in the tax court. So in the case of income, estate, and gift tax penalties, the IRS has an obligation to advise the taxpayer of his or her due process rights to file a protest petition in the tax court, or to file a protest with IRS appeals. In the case of a trust fund recovery penalty assessment, the IRS need not provide the taxpayer with notice of his or her procedural due process rights to prepayment litigation in tax court. Instead, the IRS need only notify the responsible person of the proposed assessment by mail to the last known address, or deliver it by hand to that person at least 60 days in advance of the assessment. The statute of limitations on assessment of the penalty is tied to the employer's statute of limitation on assessment of the underlying trust fund taxes. The statute is 3 years if the employer filed a return, and time immemorial if the employer failed to file a return. If the employer fails to file a return and agrees to extend the statute of limitations on assessment or collection of the trust fund tax liability, the trust fund recovery penalty is not also extended. Also, if the employer obtains an installment agreement with respect to the trust fund taxes, the statute of limitations for assessing the penalty or collecting from the person assessed is not also extended. If the statute of limitations on the trust fund recovery penalty is in jeopardy, the IRS may ask the responsible person to consent to extending the statute on assessment of the trust fund penalty. It is suspended upon mailing of the notice required before assessment from the date of the notice through the later of, and here you have 90 days after the date of notice, or if the taxpayer makes a timely protest 30 days after the IRS makes its final administrative decision. And you should note that there is an exception for jeopardy. Now, here we get into the IRS's policy to collect only once. So the IRS here is looking to collect the underlying trust fund tax, but they do it within the context of somewhat being understanding and going after and collecting it only once. Now, obviously, people would say, "What? The IRS is going to collect twice," and not to give them any benefit of the doubt here, but they want to get the underlying trust fund tax. And the idea here is, even if a number of individuals are named as responsible persons, at the end of the day, if one person out of that number steps up and pays it, they're not going to go after the other two individuals because the amount has been collected. So they're not trying to make this punitive. However, it can obviously be perceived as punitive by any one of a number of people who are labeled the responsible person. But at the end of the day, the IRS just wants to collect the trust fund liability tax. And like I said, if one person steps up and pays it in full, then they don't care if so long as it's paid. If three people split it jointly and severally, and the full amount winds up getting paid, then the IRS is satisfied. So it's viewed from this perspective as a collection mechanism for the unpaid trust fund taxes and not an actual penalty imposed to punish each responsible person. A literal reading of this section would seem to suggest that the IRS could impose the delinquent trust fund tax upon each responsible person, so that in theory the IRS could collect the trust fund tax multiple times. But again, that's not what they do. It's not a punitive penalty. Obviously, imposition of the trust fund recovery penalty on each responsible person would have the maximum deterrent effect. However, as interpreted, the IRS only collects the trust fund penalty once. Practically speaking, this means that if the employer itself pays the delinquent trust fund tax, the IRS will not pursue those who were technically liable under 6672 when the tax became delinquent. Shrewd persons potentially liable under 6672 after using the trust fund tax for other purposes may embrace a strategy of sorts. And that strategy may include pressuring the employer to pay the trust fund taxes before going under. And that's not a strategy, it's just common sense that a responsible person would go directly to the employer and ask the employer, or implore the employer to step up and pay the penalty. Because at the end of the day, it's the employer that had the obligation. But in this context, you could be any one of a number of responsible persons. Sadly, however, there's usually nothing left over to pay these trust fund taxes. When the IRS is having trouble collecting from the employer, a typical strategy employed by a disgruntled person against whom the IRS has asserted the penalty is to point the finger and, in this sense, become a whistleblower of sorts at other people within the organization with the hope that the IRS will pursue these other people instead. So basically, the responsible person isn't happy that they've been given that title and are on the hook for the penalty. So they may first go to the employer itself and ask the employer to pay the amount. Oftentimes, the employer doesn't have the funds to do so, and when that happens, the responsible person will start naming the names of other individuals and pointing the finger at other individuals who potentially are liable for the penalty or may even have more culpability for the penalty. The disgruntled person may even assist the IRS in locating assets of other putatively responsible persons in the hope that the IRS will levy against them first. You know, as unseemly as this strategy may seem, if the IRS succeeds in collecting the trust fund tax from one of these other persons, the disgruntled person will have avoided the inevitable being liable to the IRS for the full amount. The IRS's policy, again, I cannot emphasize this enough, is to collect only once. And this requires that it scrupulously adhere to administrative issues in the implementation of the policy so that it only collects once. For example, the IRS may negotiate an installment agreement with the employer to pay the unpaid trust fund taxes over a period of time that spans well beyond the expiration of the statute of limitations for assessment of the penalty. According to the IRS policy, normally it will not pursue the trust fund recovery penalty during the period that the installment agreement is in effect and being honored by the employer. However, if the installment period extends beyond the statute of limitations, the IRS may proactively assert the penalty in order to protect itself against the possibility that the employer defaults on the installment agreement. So, this just goes to say that the installment agreement must be honored and must be upheld in good faith. If not, the IRS is certainly going to be proactive and protect its interests. And it's always concerned, or looming in the back of its mind, is always the possibility that the employer might default and go belly up on the installment agreement. And so, if the installment period extends beyond the statute of limitations, the IRS may certainly, as a matter of course, have the taxpayer, agree to an extended statute of limitations. And the statute may require that the IRS take other precautionary measures. Here's a quick example. Suppose that within the 3-year limitations period for assessment, the IRS determines that Adam and Bob are liable for the penalty. Adam has resources that may easily be tapped into by the IRS to pay the full trust fund tax delinquency. Bob, on the other hand, only has some resources, and they are scarce and not easily accessible. He has a large equity cushion in his home, and in this case, it's his primary residence. And the IRS, practically speaking, does not like to levy on a home when it's the taxpayer's primary residence for obvious reasons. Since the IRS can, if it chooses, pursue only one of them, even though both are equally liable, will the IRS assert the trust fund recovery penalty only against Adam and collect from Adam? Examining it from this perspective of the IRS, it might make better sense to pursue Adam exclusively in order to avoid the unnecessary expenditure of scarce resources on Bob and having to go through all the hoops of getting a levy against the home of Bob and having to do something that is probably going to backfire PR-wise against the IRS by pursuing the primary residence of a taxpayer. They certainly, as I said earlier, don't like to do that. That's usually a case of last resort when the IRS will go after the primary home, simply because that's where the person lives and where the family resides, and the IRS doesn't want to develop the reputation of seizing or of taking a taxpayer's home. The best laid plans of mice and men oftentimes go awry. So what if Adam files a refund suit within the applicable period of limitations? This would be a doomsday scenario. Why? If the assessment against Adam was made at the end of the 3-year statute and Adam initiated his refund suit after the 3-year statute on assessment had expired, the IRS would be at risk that Adam would prevail in the refund remedy and the IRS would be unable to assess against Bob. So to eliminate this risk, the IRS will proactively assess against Bob, although it may but need not refrain from collecting from Bob until Adam's refund statute of limitations has expired, or if Adam pursues a refund, Adam's potential for recovery has been denied with prejudice. What if the IRS assesses against both Adam and Bob and afterwards collects the entire amount from Adam or even collects from the employer under an installment plan? Under this scenario and under the policy of collecting only once, the unpaid assessments against Bob or against Adam and Bob respectively would be abated. Of course, if the employer paid, he would not be entitled to a refund. So upon payment or even partial payments by the employer, the assessments against Adam and Bob could be abated. But assuming the IRS collects only from Adam, it must postpone any abatement of Bob's assessment until Adam is foreclosed from pursuing his refund suit due to the closing of the statute of limitations, or if he's pursued a refund until such time as his recovery has been denied with prejudice. So these examples demonstrate that the statute of limitations may force the IRS to proceed against the responsible person, even when it's possible that, given a little more time, the IRS may be able to collect against the employer or even against another potentially responsible person. So yes, in some cases, because of the clock ticking on the IRS, they might pursue Adam and Bob, even though they're close to some type of agreement with the employer, where the employer perhaps inks an installment agreement with them. So it doesn't mean that the IRS is being punitive by going after both responsible individuals. It just doesn't want to be held holding the bag at the end of the day. It wants to ensure that it recovers the full amount of the trust fund recovery penalty. And again, it can't trust the IRS, that is, it can't trust that the company is going to be solvent and will have the full amount. And that's why it's going to potentially make assessments against every responsible person that it has found during its investigation. The person may want to attempt to negotiate with the IRS by agreeing to an extension of the limitations period for assessment in the hope that the IRS's need to assess the tax against him will be negated as a result of payment by someone else. Because of the policy to collect once, a taxpayer against whom the trust fund recovery penalty has been asserted may request and receive from the IRS the following information, despite the general rule that taxpayer return information not be disclosed. First, the person is entitled to the name of any other person against whom the recovery penalty has been asserted, and second, the nature of the IRS's collection efforts against such other individuals and the amount collected. A person who has been assessed the recovery penalty may find this information helpful in assessing what his exposure is, and based on that might take certain action. So just going back to the example that we discussed above, assume Adam and Brian have been assessed the penalty, both are clearly liable for it, and that after making the assessments, the IRS is fully collected against Adam.
armed with this information, which Brian would be entitled to, Brian may be able to thwart collection efforts by the IRS, subject to any action the IRS deems necessary to ensure that Adam doesn't successfully pursue a refund claim. So in this scenario, and this is the theme that has been carrying through this whole hypothetical, the IRS has a legitimate concern that Adam can pursue a refund claim. And unless and until such time as the statute of limitations for pursuing that claim have expired, or until Adam has unsuccessfully pursued that claim and it's been denied with prejudice, the IRS isn't too willing to let the second taxpayer off the hook. In this case, Brian. In the former case, it was Bob. So the IRS is going to assess against both parties. Even if the IRS were to proactively initiate collection against Brian, Brian might consider his ultimate exposure in light of the IRS's one collection policy. And that basically concludes that section, and we're now moving on to collection due process. This will be the last topic that we cover in this presentation. Collection due process offers a possible judicial remedy for some trust fund recovery penalty determinations. It's not available until the IRS first makes an assessment and second files a lien or levies on the taxpayer's assets. The question that comes up most frequently in the context of collection due process for trust fund recovery penalty is, can the court consider the merits of the trust fund recovery penalty liability? This depends on whether the responsible person had an earlier opportunity to dispute the liability. So it's no different than in other cases when we're talking collection due process and we're at the stage of tax court and filing the petition and whether the merits of the liability can be considered. The general rule here is that if the individual had a prior opportunity to dispute the liability via appeals, usually the traditional way is that the person had filed a protest in the appeals section of the IRS and disputed the underlying tax liability then. In that case, he or she would be foreclosed from disputing the underlying tax liability at a collection due process hearing in tax court. This limitation on the tax court's jurisdiction is designed to basically incentivize the party to pursue earlier available remedies for contesting the merits. The classic case where an earlier remedy for contesting the merits of an underlying tax liability exists is in the wake of receiving a notice of deficiency. So, as I mentioned before, the taxpayer can file a protest to IRS appeals in order to attack the merits of the underlying liability, or the taxpayer might skip that step altogether, and there are some taxpayers who do that and go right to tax court, in which case they, because it's their first bite at the apple on attacking the underlying tax liability, will be allowed to dispute the merits. And so they would wait for what's called a notice of deficiency, and that's usually their ticket to tax court. Now, what's been happening these days is that even those taxpayers that skip the step of going to IRS appeals and using that as a possibility to dispute the underlying liability, if they bypass that step and go to tax court by filing the petition, tax court might look at the record and see that the taxpayer has not gone to appeals and not had an IRS appeals officer look at it, and they might automatically send it back to IRS appeals. In fact, it's becoming not only recommended, it's becoming part of the process in cases where the disputed amount is under a certain threshold. But the responsible person is not issued a notice of deficiency, and keep this in mind, the responsible person is not issued a notice of deficiency before the trust fund recovery penalty is assessed, because one's not required. So the argument can be made that the responsible person had no judicial remedy prior to assessment. And so the notice of deficiency is sometimes used to bar the person who is contesting another penalty from attacking the merits in tax court. But that argument cannot be turned around on the taxpayer who's assessed the trust fund recovery penalty, because when the trust fund recovery penalty is assessed, the responsible person is not issued a notice of deficiency. And so that gives way to the argument that the responsible person had no judicial remedy prior to assessment. But once there is an assessment and the trust fund and the taxpayer pays a relatively small amount to pursue a refund penalty, the taxpayer does have a judicial remedy. So the question becomes, does the availability of that post-assessment remedy foreclose the tax court jurisdiction over the merits? Now, unfortunately, at this time, there's been no such holding. However, one might infer from case law that's previously been decided that there would be jurisdiction. Ironically, the opportunity to dispute may not even require a judicial remedy. And in those cases, you want to keep in mind that the responsible person does receive some type of notice. It's a paltry notice compared to a notice of deficiency, entitling him or her to administrative review with IRS appeals. And this alone, assuming it was received, may be enough. Assuming the collection due process remedy is available, the downsides of using the CDP procedure to contest the merits are the following. First, the lack of a jury or a generalist judge, and second, the lack of robust discovery in tax court. The upside will be the government's inability to force the other responsible persons into the litigation, with the result being reduced costs due to the absence of multiple parties, and second, avoiding having to deal with those missing persons' claims that the party invoking the collection due process remedy is actually the responsible person. So in other words, cross-claims. When the employer invokes the CDP remedy, collection of the employer's liability for trust fund taxes is automatically suspended until the proceeding has ended. However, there is no bar against the IRS asserting or attempting to collect the trust fund recovery penalty from a responsible person while the employer's CDP remedy is pending. Now we get into bankruptcy. We're going to end here. We've gone on for a while now. If you have any questions about what we covered here, please feel free to send me an email. I don't have it on a slide, but my email address is M as in Michael, J as in James, my last name DeBliss, D as in David, E as in Edward, B as in boy, LIS @theblisslaw.com. It's been a pleasure presenting to you, and I look forward to seeing you at next week's presentation on Wednesday at the same time, 11 a.m.